Myself, Raksa Patel, from Mahatma Gandhi Institute of Technical Education and Research Center, Navsari. I am working as an assistant professor in computer department. Now, today we are going to learn about fundamental rights of Indian Constitution. Now, first of all, we see what is the fundamental rights. The fundamental rights are defined as the basic human rights of all the citizens. These rights are defined in the part 3 of Constitution, applied irrespective of race, place of birth, religion, caste or gender. They are enforceable by the courts, subject to specific restriction as necessary for the protection of public interest. It is also called Indian Bills of Rights. Now, originally Constitution provides 7 fundamental rights, but the right to property was removed from the list of fundamental rights by the 44th Constitution Amendment Act at 1979, and after amended it was made legal right. At present there are only 6 fundamental rights. They are described below. The first fundamental rights are the right to equality under the article 14 to 18. The second fundamental rights is right to freedoms under the article 19 to 21 define the freedom for human. Next fundamental right is right against exploitation, which contain the article number 23 and 24. Next, right to freedom of religion under the article 25 to 28. Next, cultural and educational right under the article 29 and 30. And last, right to constitutional remedies under the article 32. Now, first of all, we see right to equality. Before that, we study the features of fundamental rights. The first feature is these are not absolute but qualify, means the state can impose reasonable restriction on them, available against any arbitrary action of state except against the private individual. In that case, only legal remedies can be made and not the constitutional remedies. They are defended and guaranteed by the Supreme Court. Next, they are not permanent as it can be repealed by a parliament but only by constitutional amendment. They can be suspended during the national emergency except the article number 20 and 21. Next, their application to armed force, parliamentary force, police force, intelligence agency can be restricted or repealed by parliament, which is defined under the article number 33. Their application can be restricted during military rule imposed under the abnormal circumstance, which is defined in article number 34. Now, first of all, we see article number 14, which is defined right to equality. Now, first of all, we see what is the right for equality. The article number 14 of the Constitutional guarantee that all people shall be equally protected by the law of countries. It means that the state can be treat people in the same circumstance alike. This article also means that individual, whether citizens of India or otherwise, shall be treated differently if circumstances are different. There are two expressions used in article number 14. The first is equality before the law and second is equal protection of the law. The expression equality before the law means that amongst equal law shall be equal and shall be equally administered. The expression equal protection of law has Its source in the US Constitution. If equal protection of law means the right to equal treatment in similar circumstances, both in privilege conferred and liability imposed. The equal protection require affirmative action by the state toward unequal by providing them facilities and opportunity. The Article 14 apply to any person including any company, association, citizen, non-citizen, natural person as well as a legal person. It indicates that there is an equal subjection of all the citizens to the ordinary law. Now the exception of the rule under the Article 14 that the rule does not prevent certain classes of persons from being a subject to special rule. For example, Article 361 is an exception to rule of law. It provides that the president or the governor or the Rajya Pramukh shall not be answerable to any court for the exercise and performance of the powers and duties of office. This is because of the reason that the Article 14 does not imply that the same law should be applied to all the person or that every law must have a universal application because of all persons are not by nature, attainment or circumstance in the same position. This article prohibits the class legislation which make the improper discrimination by conferring particular privilege upon the class of person arbitrarily selected, but it permitted reasonable classification for the purpose of achieving the specific ends, which is also not the exception rule of law. The publication of proceeding of parliaments and state legislature, which is defined under the Article 361A. Also, powers, privileges of House of Parliament, which is defined in Article number 105 and Article number 194. UNO and its agency also enjoy the same powers, and Article 31C is also exception to Article number 14. Now, the next article, that is Article number 15, which defines the social equalities and equal access to public area. The Article 15 of the Constitution states that no person shall be discriminated on the basis of religion, race, caste, or place of birth. Every person shall have the equal access to public area like public parks, museums, wells, bathing, etc. State may make any special provision for a woman and children. As per the Article 15(4), the special provision may be made for the advancement of any socially or educationally backward class or scheduled caste or scheduled tribe. For the purpose of Article 15(4), backwardness must be both social and educationally, and the caste cannot be made the solely of dominant taste for determining the backwardness of the class of citizen. It was held that order under the Article 15(4) need not be in the form of legislation, it can also be in the form of executive order. Especially in speaking generally and in a broad way, a special provision should be less than 50%. The actual percentage must be depend upon the relevant prevailing circumstance in each case. Now article number 16. The article number 16 which equality in matter of public employment. The article 16 of Constitution lays down that state cannot be discriminate against any 1 in the matter of public employment. All the citizens can apply for government job. However, there are some exceptions. However, this does not prevent the state from laying down the requisite qualification for recruitment in government service. It also prohibited discrimination by the state in the relation to employment or appointment to any office under the state on the grounds only of religion, race, caste, place of birth, resident, or any of them. Article 16 allowed the state to reserve the seat in favor of backward classes of citizens which, according to state, they are not adequately represented in the service under the state. This may be meant for the posts that require knowledge of locality and languages of era. The Article 16 also apply in matter of promotion, consecutively and seniority. The reservation shall not exceed the 50% limit. Carry forward rule invalid provided it should not result in breach of the 50% rule. Next, the Mandal Commission. In the landmark case of Indra Savne versus Union of India, also known as a Mandal Commission case, the Supreme Court dealt with the various aspects of complex issue of reservation and gave out of very thoughtful judgment. Some of key aspects of judgment are creamier must be excluded from backward classes. Article 16.4 is not exception to Article 16.1 but an independent clause. The Article 16.4 is exhaustive of the subject of reservation in favor of backward classes. Though it may not be exhaustive of very concept of reservation. The reservation for other classes can be made under Article 16.1. The reservation shall not be exceed the 50% limit. The reservation is appointment under the Article 16.4 confined to initial appointment only. There shall be no reservation in promotion. The backward class referred to Article 16.4 shall not be same as the socially and educationally backward classes referred to under Article 15.5. The Article 16.4 permit the classification of backward classes into the backward and the more backward classes. In the aftermath of Mandal Commission judgment, Clause 4A was added in Article 16 by the way of 77th Amendment Act at 1995, providing for reservation in matter of promotion. Commission in its reports in 1980 state 3,743 caste as SCBC and recommended 27% reservation for the same. So the total reservation amount to be 50%. It was enforced in 1990. Again, in 1991, it was comprehended the same to give the priority to the poor section of OBC by enacting income criteria and also proposed 10% reservation for higher class on the basis of income which are not covered in reservation. The Supreme Court reviews for this is validate and approve 20% reservation for OBS as suggested by Mandal Commission in 1980 but rejected 10% for EWS as suggested by government in 1991. The certain conditions were imposed. The first is advance action, creamier of OBC should be excluded, no reservation in promotion and existing reservations should be for 5 years only and total reservation should not exceed the 50% except in extraordinary situation. Next, article number 70 which is define abolition of untouchability. Article 17 of the Constitution, abolition the practices of untouchability. The practices of untouchability is an offense and anyone doing so is punishable by a law. It can be termed as one of the earliest efforts made in the direction of social reform, since the article contemplate the practices of untouchability to the punishable offense, the legislature enacted the Protection of Civil Liberties Act 1955, previously known as an Untouchability Act 1955, do prescribe the punishment for untouchability and other practices connected with it. The word untouchability has not been defined either under Article 17 or the Protection of Civil Liberty Act 1955. The term has not been used in the article in the literal or grammatical sense. It is actually referred to the social disabilities historically imposed on certain classes of people by reason for their birth in a certain caste and would not include in instigation of social boycott by the reason of the conducted of certain person. The word reason prime facies to refer to an untouchable. The untouchability is an integral part of the caste system and it is not based on the mens rea. The person convicted for the same is disqualified for the election, nomination in general and assembly election. The following acts are offensive as per the Protection of Civil Rights Act 1995. 1995. The preventing any person from entering any place of public era, public worship, denying access to any shop, hotel as a place of public entertainment, refusing to admit any person in hospital, educational institution or hostels which is established for public benefits, insulting a person belonging to SC on ground of untouchability, refusing to sell goods or vendor service. These are offensive as per the protection of right. Now next, that is article number 18 which define the abolition of titles. Article 18 of the Constitution prohibits the state from conferring any titles. Citizen of India cannot accept a title from foreign state. The British government has created an aristocratic class known as in Rai Bahadur and Khan Bahadur in India. This title were also abolished. But it cannot be applied to any educational and military can be conferred to one citizen of India. The award of Bharat Ratna and Padma Vibhushan cannot be used by the recipient as a title and do not according come with the constitutional prohibition. The Supreme Court on the 15 December 1995 upheld the validity of such award. The article number 18 not apply to educational and military. So provide the degree, for example, bachelor engineering, master engineering. So which that type of degree apply, matlab that type of title apply to educational, but we cannot provide any type of title to our country, for example, Rajasahi and all that. So next rights we can learn in next lecture.